Hello everyone, this is Mr. Lipchick, and our topic of discussion for this segment is going to be the rights of the accused, the rights that are afforded under our Constitution to individuals who are accused of a crime. Our system of government tries to balance the rights of the accused with the need to protect society. The Fourth Amendment guarantees citizens against unreasonable searches and seizures. In order to protect society, police sometimes need to search homes, cars, offices, and persons. It is the job of the courts to determine the meaning of unreasonable. In order to justify a search, police must swear under oath that they have probable cause of suspecting a person of having committed a crime. Usually, they have to obtain a warrant from a court before searching property or arresting someone. The warrant must describe the place to be searched and the person or things to be seized. They can't just go out on a fishing expedition with a warrant. It has to be specific. Prior to 1980, 23 states had laws allowing police to enter a home if they had cause to believe that the occupant committed a felony. In the Supreme Court case Payton versus New York in 1980, the court ruled that, except in a life-threatening emergency, the Fourth Amendment forbids searching a home without a warrant. So unless it's clear that somebody's going to be killed, somebody screaming inside, something of that nature, they need a warrant. In Florida versus JL in 2000, the court ruled that an anonymous tip that a person is carrying a gun does not give police the right to stop and frisk that person. There are special situations. Police do not need a warrant to search and arrest a person that they see breaking the law. In Wren versus the United States in 1996, the court ruled that police can seize drugs found in a suspect's vehicle when they stopped him for a traffic violation. In Atwater versus City of Lago Vista, 2001, the court ruled that Fourth Amendment protections did not apply to a woman stopped by police for driving her children without their seatbelts on. In California versus Greenwood in 1998, the court upheld a warrantless search of garbage because people do not have a reasonable expectation of privacy in garbage placed outside the home where it can be inspected by the public. In Weeks versus the United States in 1914, the court established something known as the Exclusionary Rule. Any illegally obtained evidence cannot be used in a federal court. In Mapp versus Ohio in 1961, this protection was extended to state courts. Exceptions to the Exclusionary Rule are as follows. In the United States versus Leon in 1984, the court ruled that evidence collected under an invalid warrant could be used as long as police were acting in good faith. In other words, they were acting in the belief that they had the right to do so. In Nixville versus Williams in 1984, the court held that evidence obtained in violation of a defendant's rights can be used at trial, but the prosecution must show that it would have been discovered eventually by legal means, and this is known as inevitable discovery. For instance, if there's a decaying body in the living room of a house, eventually somebody's going to see it. Other important rulings on searches and seizures. In California versus Escovedo, 1987, the police are free to search an automobile and the containers within it if they believe the containers have contraband or evidence within them. In New Jersey versus TLO in 1985, the court ruled that school officials do not need warrants or probable cause to search their students or their property, only reasonable grounds to believe that evidence will be discovered. And in Katz versus the United States in 1967, the court extended Fourth Amendment protections to include protections against wiretapping without a warrant. The right to counsel. The Sixth Amendment guarantees defendants the right to an attorney. For many years, however, this right only applied to federal and not state cases. The result was that only people wealthy enough to hire attorneys could receive fair trials. The Supreme Court cases eventually determined that the accused had the right to an attorney at the state level as well. In Powell v. Alabama in 1932, the court ruled that states had to provide an attorney in cases involving the death penalty. In Betts v. Brady in 1942, the court ruled that states did not have to provide lawyers in cases not involving the death penalty, except for special circumstances such as mental incompetence or illiteracy. And the famous landmark case of Gideon v. Wainwright in 1963, the court ruled that state courts must provide attorneys for defendants if they cannot afford one. There is Clarence Gideon to the right, and he started his own appeals without a lawyer. Many prisoners were freed because they had been tried without defense attorneys. And any case in which a defendant can receive 6 months or more in prison requires that an attorney be provided for him or her. Protection against self-incrimination. The Fifth Amendment to the Constitution protects defendants against self-incrimination. No one shall be compelled in any criminal case to be a witness against himself. The burden of proof of guilt is on the government, and the defendant is not obliged to testify. It is also protection against coerced confessions, beating a confession out of somebody, as they used to do in the old days. Two important Supreme Court rulings have defined this right. One is Escovedo versus Illinois in 1964. Danny Escovedo was interrogated under suspicion of murder without being advised of his constitutional rights. Escovedo made incriminating statements after a long interrogation, which were used to convict him of murder. The court reversed Escovedo's conviction, ruling that his right to an attorney and right against self-incrimination had been violated. In Miranda v. Arizona in 1966, the court ruled that Fifth Amendment protections against self-incrimination require that suspects be informed of their rights before police question them, and these have become commonly known as the Miranda rights. Other cases have modified these rights. In Oregon v. Elstad in 1985, the court ruled that statements made by suspects before they are informed of their rights can be used as evidence. In Arizona v. Folamonte in 1991, the court ruled that a forced confession did not void a conviction if other independently obtained evidence sustained a guilty verdict. Double jeopardy. The Fifth Amendment states that no person shall twice put in jeopardy of life and limb. This means that a person cannot be tried twice for the same crime. A person can, however, face criminal charges and civil penalties for the same act. If a crime violates both state and federal laws, a person can be tried at each level in that case. The state and federal governments have been ruled as separate sovereigns. cruel and unusual punishment. The Eighth Amendment forbids cruel and unusual punishments. The greatest controversy regards how this protection relates to the death penalty. In Furman v. Georgia, 1972, the court ruled that capital punishment, as then administered, was not constitutional. Basically, there were wide racial disparities in who received it. It was administered in arbitrary ways and mostly affected African Americans and the poor. In Gregg v. Georgia in 1976, the court ruled that the death penalty did not constitute cruel and unusual punishment if administered under adequate guidelines. That concludes our segment on the rights of the accused. Thank you for viewing, and I look forward to seeing you in the live lesson. Have a great day.